Good morning to all. I'm Chief Justice Tom Parker, and on behalf of the Supreme Court of Alabama, I thank you for being here this morning for this special oral argument session.
We've already had a trial. The trial was decided on February 22nd last year. The conflicts in the evidence were decided by a jury, and it is not this court's role to be re-examining these conflicts in the evidence that Mr. Lemke is talking about here today. And I was also reminded during his comments about the admonition from this court in Hammond v. City of Gadsden that the trial judge is better positioned to weigh conflicts in the evidence, to comment upon what happened at trial, and to inform this court of what the ultimate just result should be. Mr. Lemke wasn't there for the pretrial hearings, the hours and hours and hours of pretrial hearings on motions to exclude witnesses, motions in limine, and understand this point from Judge Pipes at the beginning of the February 4th hearing on all the pretrial motions. This is dispositive of all the evidentiary issues they've raised. Judge Pipes said, quote, "And this is across the board on these motions to exclude experts and or the motions in limine. Keep in mind, these are pretrial motions, and we're all guessing at what may or may not be said, that kind of thing. This completely leaves the door open for objections at trial if either party feels like we're going into issues that either a witness is not qualified to give an opinion on, relevancy, all that kind of thing." So what happened with respect to Dr. Rothfield? Dr. Rothfield testifies at R700 through just before R900. He's qualified at 701 to 720. At 721, Mr. Lee concedes he's qualified as a hospital opioid patient safety expert. So he goes on to give his testimony. And then my partner, Mr. Duncan, asks him a question. Assuming Spring Hill had complied with the requirements of the standard of care and put the policies and procedures in place as advocated by the Joint Commission and all the standard of review literature. Now bear in mind, we had 380 demonstrative aids that went to the jury, 88 exhibits that were admitted, a mountain of nursing literature, hospital literature, standard of care literature. And so the question to Dr. Rothfield was, if the hospital had done what it should have done, what would you expect a pharmacist to do? And Mr. Lee objected, and the objection was overruled. And then Dr. Rothfield was asked, what would you expect a nurse to do if the hospital had done what it was supposed to do? The objection was overruled. Then Dr. Rothfield testifies, I would expect a nurse to recognize that 4 milligrams of Dilaudid is an enormous dose that would never be appropriate, and it was confusing. And I would expect a nurse in that situation to call the doctor and say, hey, Dr. McAndrew, this is Nurse Ellenwaugh. I've got Mr. West here, and he's complaining of pain. I'm looking at your order. You don't really want to give him 4 milligrams every 3 hours, do you? But that didn't happen either. No objection. This testimony is coming in without objection. No request for a continuing objection. So the testimony continues. And not only did Nurse Ellenwaugh give this huge dose of Dilaudid, she gave another dose over an hour earlier than the doctor had even prescribed it. So to me, it was really, this is the most egregious overdose of Dilaudid I've ever seen in my career. I can't imagine how this could happen in a hospital. No motion to strike, no objection, nothing. And so we go on for another 150 pages of testimony. Then, when Mr. Lee has his opportunity to cross-examine Dr. Rothfield, he asks the very question that they're complaining about today. He asks the standard of care question to Dr. Rothfield about Nurse Ellenwaugh. He asks, referring to Nurse Ellenwaugh, to give Dilaudid, the doses she had to give was 4 milligrams. He asked that question of Dr. Rothfield. And Dr. Rothfield answers, I disagree with that, and let me tell you why. A nurse's primary responsibility is to the patient and to keep the patient safe. A competent nurse would never have administered 4 milligrams of Dilaudid to the patient. A nurse can always refuse a doctor's order if she believes that it endangers a patient. No objection, no motion to strike. We get a motion to strike the next morning after Dr. Rothfield's been put on an airplane and flown back to Texas. So Health Trust versus Cantrell is dispositive. Unless you make a timely objection when the evidence is offered, there is no error preserved for review. And that's why we point out in the red brief the Rule 28A5 problems, and they permeate all the issues. This court has amended the rule to require an appellant to list the page in the record where the issue was raised and preserved, and it wasn't throughout the brief.
Can I steer you, just limited amount of time, back to some of the questions I had for Mr. Lemke on the Hammond green oil? I won't ask you your thoughts on whether the med-mal cap should be reinstituted. I suspect I know your answer.
I have an answer if you'll ask
A respectful answer on that. If we get to the Hammond green oil issue, and I understand that's always a big if, the way this case is postured.
Yes.
But are you aware that this court has ever gone through a Hammond green oil analysis on a med-mal wrongful death where we've upheld more than $10 million?
No, sir.
Okay, so do you think Bednarski is the most recent pronouncement? I think that was 6 or 7.56.
The verdict was originally going to be 10. There was a $1 million pro tanto. The verdict was returned at 9.
Okay.
Lee County Circuit Judge Jake Walker remitted that to 6.5.
So 6. So Bednarski's probably
the latest.
In
gross.
We're in agreement on that. So again, I know you want to keep the 10. That's obvious, but the legal basis, let's throw it out that way in response to what the defense is.
I'll give you the evidence of reprehensibility, and then I will urge you to give deference to Judge Pipes for the same reason that I brought up initially about Hammond versus City of Gadsden. You were a circuit judge. Justice Stewart, you were a circuit judge. You know the responsibilities of circuit judges. In Bednarski, you, in a per curiam opinion, gave great deference to what Judge Walker wrote as his post-judgment order. That order was submitted by plaintiff's counsel, and he copied it word for word. I love Jake Walker. We went to Swanee together. He's a friend, but he took the plaintiff's proposed order. We submitted a proposed order in this case. Judge Pipes, despite COVID, despite Ashley Rich demanding that criminal cases go first, Judge Pipes took the time to write the 22-page order that's before you. Carefully reasoned, thoughtfully researched, grammatically correct. Judge Pipes took the time to tell you what the outcome should be, and that should be afforded the greatest deference based on what he observed in the trial. Now, the reprehensibility evidence.
And yeah, about his argument that Nurse Elenois, that they're not responsible for what it appears to be everyone's conceding that she was untruthful in her deposition.
There's no case law. He wants to say that anybody can come up after the fact and go quit and go work for some other employer in some other state and be exonerated.
I do think that's what he's saying.
That's what he's arguing, but there's no case law and he doesn't cite any. And why would that ever be this court's policy? She committed the tort while within the line and scope of her employment with Spring Hill. That was admitted. The jury was charged she was an employee of Spring Hill without objection by Spring Hill. So her conduct, whatever it is Spring Hill's conduct. And we invited her to come to trial. They could have brought her to trial. They didn't. So the jury heard what her testimony was. Evidence of reprehensibility. For decades, this hospital disregarded the responsibilities of hospitals similarly situated in this country. And you have evidence in the record from Dr. Lou Nelson, the foremost toxicologist in the country, probably the world, who works presently at the New York University Hospital System. And Dr. Nelson said, the New York University Hospital System has doing post-surgical monitoring of patients like Mr. West for years before 2014. Same thing with the Rutgers University Hospital System. That's his testimony. Barbara Levin, our nurse expert, Massachusetts General Hospital System, throughout the state of Massachusetts, affiliated with Harvard University. They had been doing post-surgical monitoring of patients like Mr. West for years in conformance with the standard of care. Kim Arnold, who was our CNO expert from Arkansas. She worked in a 123 hospital unit, and she testified as well. Every hospital in its system uses post-surgical monitoring. Dr. Rothfield, Texas Arlington, the largest Catholic hospital system in the country, testifies. Throughout the entire network, including Providence Hospital in Mobile, they do what the standard of care requires. Spring Hill elected not to do that. And you have admissions throughout our briefing, throughout the record in this case, and I'd urge you to look where we didn't have a word count limitation in the post-judgment briefing. You know, I've got an 8,000-page record, an 11-day trial, 27 witnesses, and I do my best to present it in the 20,000 words that I was allotted in this appeal, but I can't do everything. Please look at the post-judgment briefing, and you'll see we catalog Paul Reed, the CNO at the hospital, admitting, yeah, we knew it. We knew of the risks. We knew of the hazards. We had the time to implement.
Let me stop you for a minute and ask you the same question I asked Mr. Lemke. This is Bednarski. Tell me why you're worse or better than this case.
I think Bednarski helps us in many respects. Waiver of the objection to the closing argument. There is no good count, bad count issue. The negligent training issue, they didn't preserve that.
I'm not asking, I'm on damages. Why is it, we affirmed before I was in the court 6.5, which would, with inflation would be over 7.
Yes.
So why, yours is 10. So why should we not say 7 if we were going to do that? Well, why are you worse or better than 7? Kind of a blunt question, but I thought our time's running out. So
Because 65410 says the damages should be in the amount the jury assesses. And that was the statute prior to the ratification of the Constitution of 1901. So it's up to the jury to determine what the damages should be. This court, as a fact finder, should not be second guessing what the jury, properly charged under APGI 1128 in a wrongful...
right, but I've got to do Hammond green oil. That's my constitutional duty. So I'm trying to understand fact-wise why the facts were worse for the defendant or better for the defendant and Bernowski.
We cover a lot of that in the red brief. You have a disregard for decades of the requirements of standard of care by the hospital CNO. You have this abject failure by this new untrained nurse to administer the appropriate medications as prescribed by the physician. And let's take a moment if we can. Just forget about the clock. Let's talk about it. She gives 4 milligrams of Dilaudid when there's no competent evidence in this record that Jay West is suffering any pain at all. The testimony from Mrs. West, and I can go through it chapter and verse, he's a big, strapping, 6'2", 310-pound man. He cuts his thumb on the day she's retiring from the Mobile County Public School System as a librarian. And they're supposed to go out and celebrate that night. He's calling her from the car on the way to the hospital. Honey, I'm sorry, I'm messing up the celebration. No pain medication in the emergency room. When he emerges from the 20-minute surgery where Dr. McAndrew fixed his thumb tip, he's joking with the nurses about not being able to play the piano. According to Mrs. West, no pain medication, no need for pain medication. When she leaves at 8:30, he's the same old jovial self. When she calls back, 9:30, according to the hospital telephone record, no complaint of pain. And 30 minutes later, Nurse Elamog gives him 4 milligrams of Dilaudid. Now, what's that mean? Some of you may have served in the military. A combat medic, when he treats a soldier in a battlefield, sticks a morphine syringe that contains the equivalent of 1.5 milligrams of morphine. She gave 28 times that amount. And then, less than 2 hours later, gave another 28 times. It's a euthanizing dose. It would kill anybody, but she didn't know any better. And the hospital didn't have safeguards in place. That's why.
Can I follow up briefly on another issue also? The $10 million, which you conceded, is that currently pending, I suppose, at the top end in Alabama. and even as a plaintiff's attorney, a policy consideration, again, not to make the physician's arguments, but certainly a corporate type entity like a hospital or a nursing home may have such resources, but typical physicians, if we're going up around 10 plus, I'm willing to venture, even if they wanted to, couldn't purchase that much insurance.
Yes.
So if we get into a diminishing return, we're getting big verdicts for, let's say, egregious behavior, not commenting on this case, but let's say it's egregious, but it's just putting doctors out of business, clinics out of business.
Justice Mendham, it's a conundrum in the state of Alabama because of the nature of our wrongful death remedy. But what we know in this case are several facts. Spring Hill has superseded the judgment. It has posted a supersedious bond in the amount.
And I understand, again, corporate type entities perhaps, but if we do 10, wouldn't that apply to an emergency room physician who's self-insured or
No, not at all.
family
because
physician? Or,
in every single case, every defendant, no matter how powerful, how wealthy, or how poor, has the right to come before this court and go before the trial court post-judgment and seek the protections that Alabama law through the Hammond, Green Oil, Gore versus BMW 61123B criteria affords them. So no, it's not one size fit all. If you entered a judgment on the jury's verdict, which is my belief, what should have been done, and that's what I implored Judge Pipes to do, respect the right to trial by jury, leave the verdict intact. But if you leave this verdict intact for $10 million, what it will do is it will have an effect on other cases that won't end up before this court because there'll be downward pressure to settle them. That's the first thing it'll do. But secondly, everyone's protected by due process to come before the reviewing court and ensure they're not punished too severely. They have the right to present evidence and say, look, this is too much. I may be guilty of the conduct, but
I may be mistaken. I was on the court for Bednarski, but it seems like in Bednarski that the physician or the clinic in that case did not have sufficient assets and insurance to come close to covering the judgment. Because it seems like, and again, correct me if I'm wrong, but we received motions because the plaintiff's attorney was executing on the judgment because the physician or clinic could not post the necessary bond. And again, the law is the law. I mean, that does happen in cases, no doubt about it, but it's a policy consideration as well if we're going to get up around 10 plus.
well, we've been confronted with this before in Boudreaux. And in Boudreaux, we conducted post-judgment discovery. And there were 2 physicians, anesthesiologists involved. And we got to the very bottom of the issue of what are their assets? What are their what will the business do in the event the judgment is ultimately affirmed in full? And Judge Smith in Mobile County, upon consideration of those factors, remitted that $20 million wrongful death verdict to $4 million, given the limits of the available insurance in that case, which were 1, and I think they had assets of 1.5, if I remember correctly, but they were a cash basis medical practice, and they were generating $8 million a year and distributing it to each of their partners.
Again, if we're using Bednarski as our most recent example, it seems like we upheld a judgment that went well in excess of any ability.
Right, they only had $1 million in Bednarski and up to 6.5.
Yeah.
And my point here is, we know that Spring Hill had insurance with Inspirion Insurance Company. Mr. McGowan's here today observing from Inspirion Insurance Company, they had liability coverage.
Mr. Wirtes, I want to redirect you in the interest of time. A number of my colleagues have covered questions about Hammond Green Oil, some of which have been on my mind too. But I want to route you back to the argument that Mr. Lemke was making about revival of the statutory damages cap. I've got a couple of questions for you there. First of all, in your view, was Schulte correctly decided?
Yes, sir, absolutely.
And why?
That was one of my cases.
I know it was. And because Mr. Lemke points to the fact that he thinks that the 2 constitutional underpinnings of that decision have been eroded, and I wanted to give you an opportunity to respond to that.
Sure. No doubt, Meloff and Apicella contain separate writings from individual justices that amount to plurality opinions of this court questioning the equal protection footing of Schulte. No doubt, that's an historical fact. But we don't want to be the court that says, because of the racists who changed Article 1, Section 1 in the 1901 Convention, that threw out the baby with the bathwater and we no longer have equal protection in this state. You don't want to be the court to tell the black people and the brown people and the red people, they don't have equal protection of the law. We have equal protection, but it's found elsewhere in our Constitution. Article 1, the way it's been rewritten, Article 1, Section 6, Section 22, Section 35, and don't forget the overarching command of the 14th Amendment of the U.S. Constitution. No state shall impose any laws that don't afford the equal protection of the laws to everyone. So we have equal protection, but it's dressed in different clothing. And even if you find there's still a fault with equal protection, Schulte was decided on right to trial by jury grounds. They don't even make a right to trial by jury argument. They just say equal protections on wobbly legs. And when you make a constitutional challenge like that, you go back to what we had to do in Schulte. We had to present evidence to show there was no rational relationship. There's no proffer of evidence to suggest today that there is a rational relationship. So what would be the predicate for any finding that they're right, other than lawyer talk?